We're going to talk about individual rights. Half of all the con law questions come from this chapter, individual rights. Equal protection, due process, speech, religion, and a variety of other little one-line definitions. Your big one right here. Individual rights makes up half of all the questions. There's 27 con law questions, so we're talking almost 14 questions from right here. So if we can get this down, and this is a combination of some law, some one-line definition with reading comprehension, and actually we can do pretty well. And if you can figure this out and you can get some confidence with these questions, whether you had the worst experience in the world in law school with this stuff, oh my God, you'll be getting 65 to 70% of these questions correct in con law because there's so many points to be had. So let's get started. The first topic, equal protection. Equal protection. What does equal protection have to do with due process? Nothing. That is exactly right. The most confused area in con law for most students is this whole thing between equal protection and due process. It's listed sometimes in this, it's listed in the same amendment, and therefore everyone mushes it together. Most people in school learned it as one big concept. We shall keep this issue separate, one thing from the other. Okay? So let's talk about equal protection. You are going to be tested either, capital E, either on equal protection or due process. Only one at a time, generally speaking. Okay? So what is equal protection about? How will I know I'm doing an equal protection question? I'm doing an equal protection question if the government, usually the state, if the state is treating people differently. Treating people differently. An equal protection issue is when the government passes a law that treats some people differently than everybody else. Doesn't mean discriminate. I don't like to use the word discriminate because that always means bad, something bad's going to happen. Doesn't necessarily mean something bad's happening. It just means the government is singling out, creating a group of people, and they're treating these guys differently than everybody else. That's an equal protection issue if I dumb everything down. Good? Does that mean it's automatically unconstitutional if they do that? No. There's no per se violation of equal protection. Just because a group of people are being treated differently doesn't mean that it's unconstitutional. How will I know if it's unconstitutional? Then it depends on who are the people being treated differently. Step one, what's equal protection look like? Some people, a group, a class as they like to call it, could be one person, 2 people, 1,000 people. These guys are being treated differently than everybody else. That's called equal protection. 2, how will I know if it's okay, if it's constitutional? Then it depends on who are the people. What group of people are being treated differently? And in order to determine the constitutionality, we apply one of the levels of scrutiny. How many levels of scrutiny are there under equal protection? There are 3. When you're driving around in the car and you're doing your review of con law and you see or hear or say the term equal protection, you should be thinking 3. 3 levels of scrutiny for equal protection. Let's go to the first one. Strict scrutiny, the big one. Strict scrutiny. Which people get strict scrutiny? Race, alienage, national origin. Race, alienage, national origin. If the group of people in your hypo are being treated differently because of their race, alienage, or national origin, then we apply strict scrutiny. What does the strict scrutiny test say? It says the government has the burden. Be careful on who has the burden. The government has the burden to show that the law is necessary to achieve a compelling interest. Government has the burden. The law is necessary to achieve compelling interest. Race, alienage, national origin, strict scrutiny. Done. Intermediate scrutiny, the middle one. Which groups of people get intermediate scrutiny? Gender, illegitimacy, usually illegitimate children. I don't know why. Gender, illegitimacy. If you're being treated differently because of your status as an illegitimate kid or your gender, treating men differently from women, we apply intermediate scrutiny. What are the elements of that? The government again has the burden. The government has the burden to show that the law is substantially related to an important interest. Substantially related, important interest. Government has the burden. Gender illegitimacy. Lastly, the little one, rational basis, the rational basis test. Who gets the rational basis test? Everybody else. If the group of people are not in the top two, it defaults to rational basis. Rational basis is called everybody else. I know there's a lot of books out there that give you a list of like 8 or 10 or 12 different groups of people. Don't memorize that. If it's not in the top two, if it's not race, alienage, or national origin, if it's not gender or legitimacy, it's rational basis. Keep it simple. What are the elements of the rational basis test? The plaintiff has the burden. The plaintiff, whoever's being, John, the plaintiff has the burden to show that the law is not rationally related to a legitimate interest. Not rationally related to a legitimate interest. Rationally related, legitimate. Buzzwords. Okay? So let's talk about this. There's two types of equal protection questions. They're either asking you, basically, how do you know you're doing an equal protection question? I know I'm doing equal protection if in the facts, what's happening? What is the government doing? I'm always talking about this in all the other areas in con law. How will I know what the issue is? Ask yourself, what is the government doing? Well, John, the state's passing a law that treats these guys differently than everybody else. Oh my God, I just talked myself into an equal protection question. The state is passing a law that treats these guys differently. They're singling them out. So when I look at the answer choices and it says equal protection, due process, commerce, privileges, and immunities, I don't want to be thinking about 3 or 4 different concepts. I know what I'm looking for. I know what I'm looking for because what does equal protection look like? People are being treated differently. Shut up and pick it. So sometimes they're basically asking you to identify it is an equal protection question. Sometimes they're actually going to tell you. John sues saying it's a violation of the Equal Protection Clause. They're actually telling me you're suing based on equal protection? I don't have to determine that. Well, if you're telling me it's already equal protection, the cat's out of the bag, I already know it's an equal protection question. So what's the issue? The issue is therefore what level of scrutiny? Sometimes will they literally say, what's John's burden of persuasion? Yes, sometimes they'll come out and say it. But when they say John sues saying it's a violation of equal protection, then you know, aha, it's already telling me equal protection. They're just asking for what level of scrutiny. Now I'm going to have the 4 answer choices, and you know that all the 4 answer choices are going to have different buzzwordy tests. But I already know what I'm looking for because I know who the people are. And how will you know who the people are? Because the facts have told you. Exactly right. What happens, John, if I know I'm doing strict scrutiny, but I get 2 answers that both say the word compelling? Well, could they give me possibly 2 answers that both quote the strict scrutiny test? Yeah, what would they be doing to me if they did that? They'll just be flip-flopping who has the burden. And if you read too fast because you're an idiot, correct, you could be giving away a free question. So one answer will say the state has the burden to show blah, blah, compelling interest. And D is going to say John has the burden, da, 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 da. Well, if I know I'm doing strict scrutiny and I know in strict scrutiny the government has the burden, I know the first answer is correct. If I know I'm doing a question about rational basis and A says the government can show it's a rationally related blah, blah, and D says John has the burden, rational blah, 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 I know D is the correct answer. Literally. 5 or 6, 10 seconds of patience to see match the burden with the buzzword, you can't get the question wrong. Are the answer choices a paragraph thick full of all kinds of other wacky nonsense and basically BS? Yes. Remember, the longer the fact pattern is, the longer the answer choices are, the more BS is involved. All you are looking for is the buzzwordy definition. What element of which test, what is each answer talking about? Don't argue, well, that would be, I like that compelling, yeah, because compelling sounds good. Don't go looking at the ceiling doing your crazy maniac lawyer thinking. Just be thinking issue, element, shut up and pick it. That question is about strict scrutiny. Where's the answer matching government and compelling interest? They don't always give you the elements of the test listed perfectly. Sometimes they leave out a word or 2 or 3 or 4 of the test. but you know what you're looking for. If you know you're looking for strict scrutiny, you're matching government and something that says compelling interest, and the other answers must and shall be talking about rational basis or substantially related. Keep them separate. Buzzword definition, that's what you're looking for. Good? Good. Let's move on. What do you mean move on, John? You mean that's it for equal protection? We spent like 7 weeks on that in law school. I know. That's why you love John and I love you, because we did equal protection in about 9 minutes. What's equal protection about? A government is treating some people differently. There's 3 levels of scrutiny. There's like 7 buzzwords I need to know for the tests. If you keep those words separate, you match the correct group of people with the right buzzword, you're getting 7 out of 10 of these right. What's the problem? Now some smart aleck is yelling 7 out of 10. Why couldn't I get 10 out of 10, John? Because we're all idiots. Because you're tired, you will misread. They will give you a question that makes absolutely no sense. Don't try to be perfect here. But the difference between 5 out of 10 in an area like this and 7 out of 10 or 6 out of 10 is all the difference in the world. Steal the questions that you can get right. We're striving to get better and better, but don't micromanage it and don't try too hard. You're trying to be 6 to 7 out of 10, not 5 out of 10. Get the 1 or 2 silly, stupid mistakes you're making at the beginning, improve on those. Everything is okay. Stay confident. Let's go to due process. There are 2 types of due process. But what does any of those 2 types of due process have to do with equal protection? Nothing. Exactly right. There's substantive due process, there's procedural due process. Substantive due process. Again, like equal protection, how do I know I'm doing a substantive due process question? I'm doing substantive due process when the government, usually the state, is taking away or regulating a right. From whom? All of us. All citizens shall not. All citizens must. If you want to do X, all people must do Y. They're taking away or regulating a right, a freedom that we all share. Substantive due process doesn't affect a group of people, because that would be equal protection. Substantive due process is about all people shall do it this way, or all citizens shall not. And it's talking about our rights, our freedoms, our liberties. Some, I emphasize the word some, rights are so important to us that they're called, excellent, fundamental rights. If the government tries to take away or affect one of our fundamental rights, then we apply strict scrutiny. What if the government tries to take away or regulate or affect a non-fundamental right? Then we apply rational basis. There are only 2 levels of scrutiny in substantive due process. There are 3 in equal protection. Okay, so substantive due process. How do I know I'm doing a substantive due process question? The government is regulating or taking away a right. We all can't do something. We all must do it this way. And who's it affecting? Everybody. That what factually should separate it from equal protection. Good? How many levels of scrutiny are there under due process? 2. So sometimes they're going to make you identify that you're doing a substantive due process question. How will I know that? Oh, this is about a law that no one can do this or everybody must do that. It's got to be substantive due process because it affects everybody. Sometimes they'll tell me, John Sue saying it violates his due process rights. Oh, you're telling me it's due process. What test will I apply? That depends. What is the right being taken away? We're not thinking who are the people, that's equal protection. Here we're thinking what right can I do? If the right that's being affected is fundamental, then we apply strict scrutiny. If it's not, we apply rational basis. So all we have to do is know what are our fundamental rights. There's a list. There's a list. There are 3 individual fundamental rights. The right to vote, anything that affects the voting process. It's not literally just stopping you from going into the booth, but anything relating to the right to vote. The voting process is a fundamental right and would trigger strict scrutiny. The right of free speech, fundamental right. And the right to travel. The right to travel, interstate travel. Interstate travel. The government affects interstate travel for John, That's a fundamental right. And for those of you who are geographically challenged, what does interstate mean? It means I literally have to leave the state. So, I'm in Florida. If I wanted to drive to my favorite place, to New York, go back to my hometown, Brooklyn, the best borough, but I love being in Manhattan also. If I was going to get on I-95 after I'm done today, and I'm going to go on 95 and drive all the way up to New York, and the government put checkpoints on I-95 and made me pull over every 20 miles to check for contraband, then I'm going to say that those checkpoints affect my fundamental right to interstate travel because I have to go through like 15 states to get to New York. If I was going to drive from Miami to Tallahassee, and the government was going to put checkpoints on the Florida Turnpike, am I leaving the state to go from Miami to Tallahassee? Tallahassee is the capital of Florida, in case you didn't know. Do I have to leave the state? No. Do I have a right to get on the highway and drive wherever I want? Yes. Is it a fundamental right? No, because it doesn't affect interstate travel. So the right of interstate travel is a fundamental right. So the three independent fundamental rights are right of free speech, right to interstate travel, and the right to vote. And now we have also, in addition, our privacy rights. Privacy rights. The right to privacy. There's a list of the privacy rights. For you mnemonic people, it's called CAMPER. C-A-M-P-E-R. C-A-M-P-E-R. C, contraception. Contraception. Fundamental right. It's not some countries you can have as many kids as you want. So if the government puts some sort of restriction on contraception, it violates your right to privacy, it triggers strict scrutiny. A, abortion. Abortion. And although abortion is a fundamental right, what is the test that we apply specifically, exclusively for abortion? The undue burden test. The government cannot place an undue burden on a woman's right to have an abortion. So even though you're thinking, well, that should be compelling because it's a fundamental right, when you're doing an abortion question, you're generally looking for the answer undue burden. Those are the buzzwords you're looking for. M, C-A-M. M stands for marriage. The right to marry is a fundamental right. Right to marriage, fundamental. Anything about the right to get married will be afforded strict scrutiny. P, procreation. Procreation. Any government law or regulation affecting procreation will be a fundamental right. Education, private education. Private education, the right to give your kid a private education is a fundamental right. Public education, non-fundamental. But you have a fundamental right, you have a right to give, you don't have to, a fundamental right to give your child a private education. And lastly, the weird one, R, C-A-M-P-R, the right to raise your family. The right to raise your family any way you want. So any law or regulation the government enacts which seems to affect what you can do, how you raise your children, how you raise your family, anything that would affect the so-called nuclear family unit, the right to raising your family any way you choose, you be thinking that's privacy. That's right to privacy. That's fundamental. That triggers strict scrutiny. So if you see a substantive due process issue where the government is affecting right to vote, free speech, interstate travel, or any of these privacy rights, CAMPER, then what answer are you looking for? Strict scrutiny. Same buzzwords we used before, John? Yes. If it's not, N-O-T, if whatever's going on in the hypo is not one of the things I just said, it's not a fundamental right, then what scrutiny do we apply? Rational basis. Rational basis. There's no intermediate scrutiny in substantive due process. Okay? So let's go back a second. Put the pencil down. Just hear me out on this. Get it in your head. Think big picture. There's equal protection. There's due process. What is equal protection? How am I going to know that's not, it's equal protection, not due process? The government is treating some people differently. They're creating a group, singling out. That's what equal protection looks like. How many levels of scrutiny? 3. Strict, race, alienage, national origin. Intermediate, gender illegitimacy, everybody else, rational basis. Who has the burden in strict and intermediate? The government. Who has the burden in rational? The plaintiff. Let's go to substantive due process. How do I know I'm doing a substantive due process question? All citizens shall. All citizens must. Everybody, in order to do this, has to do it this way. You're either taking away a right from everyone or you're regulating a right. Everyone must do it this way. Who's being affected? Everyone. Sometimes they will tell you, John sues, saying it violates equal protection. I know to apply one of the scrutinies. Sometimes it'll say John sues, saying it's a violation of due process. Always apply one of the scrutinies. And how many are there in substantive due process? 2. Because either what you're taking away from me is fundamental or it's not. Not bad. Now I'm going to give you some hypos and you scream at the camera and tell me which one is which. Okay? Here we go. Put the pencil down and just listen. Take a drink. Here we go. Slap yourself in the face. Everything is okay. Once you get this, you won't believe how easy this is. The state of Florida does a 10-year study, and they determine that there's too much violence at sporting events in Florida. Everyone's getting drunk and beating the hell out of each other at the stadiums. It's too dangerous. The state of Florida also determines that fans of the New York Jets are the most riotous and violent of all sports fans. So the state of Florida passes a law that says fans of the New York Jets shall not attend football games in Miami, Jacksonville, and Tampa. John Grossman, president of the Jet Fan Club Association of Florida, sues saying it's a violation of his constitutional rights. John's strongest argument to overturn the statute would be, now I'm going to get A, B, C, D. It only says John sues saying it's unconstitutional. I didn't say the name of the issue. Now I'm going to get 4 answer choices. Equal protection, due process, privileges and immunities, commerce. So again, too much violence at public sporting events. State of Florida passes a law, always ask yourself what the statute talks about, passes a law that prohibits Jet fans from attending football games in the state of Florida. John, president of the Jet Fan Club Association, sues in federal court saying it violates his constitutional rights. John's strongest argument would be A, due process clause, because it violates John's liberty right to go to any football game he so chooses. B, commerce clause, because it would affect all the people who fly down to Florida and stay in hotels and eat in restaurants and buy the foam #1s and paint their face green. C, privileges and immunities, because John's originally a resident of Brooklyn and you're discriminating against people from New York. D, equal protection clause, because John's stupid enough to be a Jet fan. D, why is that an equal protection issue, even though the other ones look good? Because what is that law about? It's about singling out who can't go to football games. Jet fans. That's a group of people. Can everyone else go? Yeah. Who can't go? Jet fans can't go. And therefore that will be equal protection because the law is singling out, treating a group of people differently than everybody else. I'll give you the same hypo. Test it a different way. State of Florida passes a law saying Jet fans can't go to football games in the state of Florida. John, president of the Jet Fan Club Association of Florida, I just like saying that as often as I can, sues saying it's a violation of his equal protection rights. Ooh, now you said John sues saying it's a violation of equal protection. Now you told me it's an equal protection question, John. You snuck it in at the bottom. Right. Once I tell you it's equal protection, all you now need to know is what level of scrutiny. Exactly. What level of scrutiny will be applicable in that question? What level of scrutiny do Jet fans get? Jet fans are just considered whom? Be careful out there, my fellow sports fans. Be careful what you're saying. But Jet fans get what classification? Obviously, rational basis, where everybody else. I've been fighting for 20 years to make Jet fans a suspect class and thereby getting strict scrutiny, but until further notice, who are Jet fans going to get? Rational basis, where everybody else. How will you know who the people are in the hypo? They're going to tell you. How will you know, therefore, who has the burden and what buzzword to look for? They're going to tell you. You already know. So you're telling me, John, that sometimes they're going to say this group is being treated differently, and then there's a guy, a plaintiff, who's going to sue, and how will I know whether it's equal protection or due process? All I do is look at the law and what the government did. And if it affects a group of people, it's equal protection. If it's everybody, it's got to be due process. And if they then say, what's the burden of persuasion, or John sues and they say equal protection or due process, I ask myself, oh, it's got to be the scrutiny thing. And an equal protection, how will I know which one of the three? Depends on who the people are. Good? Good. I'll give you a couple more hypos, quick ones, and you tell me what's what. In most cities across the country, you can't smoke in public places, right? There's a ban on smoking in public places, okay? So if the city passes a law saying nobody can smoke, smoking is prohibited in these places, restaurants, public places, etc. Who can't smoke? Anybody. Is that an equal protection issue or a due process issue? Due process, because nobody can smoke. What if they ask for the level of scrutiny? What level of scrutiny would the smokers get? Rational basis. Is smoking a fundamental right? Well, the smokers think so, but is smoking on the list? No. Rational basis, I already know what I'm looking for. If I change that hypo and I said, God forbid, people with emphysema can't buy a pack of cigarettes. Now who am I affecting? Now I'm affecting a group of people, exactly. And now what issue are we talking about? Equal protection, excellent. What level of scrutiny would those people get? Rational basis, everyone else. The state of Florida, God forbid, does a 10-year study and finds out that too many people in Florida are getting melanoma, the skin cancer, God forbid, because we're all out in the sun and the UV rays and the global warming and all the dangers of the sun, it's now affecting too many of us. So the state of Florida passes a law, no citizen shall go to the beach from Memorial Day until Labor Day when the sun is at its most dangerous. John Grossman, president of the Sun Worshippers Association of Florida, sues in federal court saying it violates his constitutional rights to go to the beach. John's strongest argument would be equal protection, because you're treating people who love the beach differently from everybody else. B, Commerce Clause, because fewer people will be able to buy hot dogs and hamburgers and corn on the cob. C, some garbage answer, I can't think that quickly right now. Or D, Due Process Clause. What's the law about? All citizens shall not go to the beach from Memorial Day until Labor Day. Who is that affecting? Everybody. Who can't go to the beach? Nobody. Therefore, is it due process or equal protection? Due process. Excellent. What if I changed the hypo and I said blondes and redheads have fairer skin and are more at risk, so blondes and redheads can't go to the beach? Now what kind of question is it? Equal protection. What level of scrutiny do the blondes and redheads get? I know blondes have more fun, haha, and the redheads are, shut up. But blondes and redheads get what level of scrutiny for MBE purposes? Rational basis, everybody else. So, after you've done 20, 30, 50, 60 questions, the closer you get to the bar, the more questions you're doing. You start to memorize these all these hypos look the same. How are you going to know if no one can go to the beach or it only affects blondes and redheads? How are you going to affect if no one can go to a football game or only Jet fans? My point is the body of the hypo looks the same, but they're just changing a sentence, a phrase, a half a sentence. That's called issue spotting, having the patients to slow down. That's how subtle this garbage is. That's why many times you do a question and you get it wrong and you're thinking, wait a minute, I did this one just like this on Monday and I got it right. This must be a stupid question. It looked like the one you did a couple of days ago, but it's not. They're ever so slightly just changing the fact pattern. The fact pattern. The law can change between now and the bar exam. The only thing that can change are the facts. Slow down. Equal protection, 3 levels of scrutiny, people. Substantive due process, everybody can't do something. We're all being regulated on a certain activity. Some of those activities are so important that they are fundamental, strict scrutiny. Most of these activities are not fundamental, rational basis. Keep them separate. Excellent. Now we go to procedural due process. Procedural due process. What's procedural due process? Procedural due process is about our property rights. Our property rights. What are our property rights? Our governmental jobs, our licenses, and our benefits, public benefits. Our jobs, governmental, licenses, professional licenses, and benefits are governmental benefits. If the government tries to take away or regulate one of those, we are talking about our procedural due process rights, and if they affect one of those property interests or property rights, we are afforded notice and a hearing. Notice, we have to be given advance notice, and a hearing. We have a right to appeal, to fight our day in court. Notice and a hearing. There are no levels of scrutiny in procedural due process. It's all about notice and a hearing. Property right. Stop for 1 second. I don't like usually to quote from these things. You know me, I'm about the basic minimal black letter law. I don't like to quote from the Constitution, but sometimes it's important. So if we're talking about due process from the Constitution, it says, no person shall be deprived of life, liberty, or property without due process of law. Life, liberty, or property. Generally speaking, when you see the term in an answer choice on an MB question, liberty right, liberty interest, that's focusing on substantive due process. Because what's our liberty rights? Our freedoms. If we're talking about our property right, property interest, if you see that term, that's an answer choice talking about procedural due process. Property interest or right equals procedural due process. So in order for procedural due process to apply, just make sure the following. Just make sure the person in the question actually has the property right, that the property right has, quote, vested. You've got it. You have the job. You have the license. If you are applying for the job, if you're applying for the license and they take it away from you, if you're on probation, do you have a property right? No, and therefore procedural due process does not apply. That's what you're looking for on these questions. So many of you out there right now do not have a property right to practice law. You're trying to get a law license, but you don't have one yet. I'm trying to help you get there. So right now, do you have a procedural due process, a property interest in the license of law? No. And that's why all of the state bar people can send you all those letters asking for all of your information. Where were you? What were you doing? Blah, blah, blah. You don't have procedural due process protection in the sense that you don't have a property right. Once, God willing, you do this the right way, you shut up and pick it, you slow down, and you get the beautiful card that you'll post on Facebook, ESQ, exclamation point, and you're all proud of yourselves, as you should be. Then do you have a property right? And if the bar people wanted something from you, do they have to give you notice in a hearing? Yes. My public defender and district attorney people out there, any of you that have tried to work or are working in a governmental job, thank God I don't know about this because I never wanted to do this. But if you, a lot of those jobs have a 30, 60, 90-day trial period, right? So you go in there, if you're in a 90-day trial period, you don't get your little parking decal or sticker or your picture ID yet. You don't get your parking spot. If on day 13 of your 90-day trial period, they come into your office and say, take your plant and get out of here, we don't want you, can they do that? Yeah, because you don't have a property right to the job yet. You're not hired fully. If it's day 100, you've been hired, you have your ID badge and your parking spot, etc. Now, what must they give you if they try to, God forbid, fire you from the job? They try to take away the governmental property interest. They have to give you notice and a hearing. So, when you think you're doing a procedural due process, what is it going to be? They're taking away your license. They're firing you from the job, affecting your benefits. As long as you've earned them and you have them, you get notice and a hearing. It's called procedural due process. Keep it separate. Good? Good. So let me get this straight, John. If I keep the equal protection separate from due process, if I focus on substantive versus procedural, and I get comfortable with what these facts look like, I could do pretty well on this. Exactly. One little rule before we go forward with some other stuff, okay? One little rule. There's the Fifth Amendment and there's the 14th Amendment, okay? Both of these apply, the Fifth Amendment and the 14th Amendment, with respect to what we're talking about now, equal protection and due process. However, what are we talking about? We're talking about which governmental entity passes the law. The large majority of the time, almost always, not always, almost always, the state. The state will be passing a law that could be violating equal protection and due process. If the state is passing a law and it's equal protection or due process, it's under the 14th Amendment. State equals 14th Amendment. Once in a while, it's going to tell you Congress passes a law that treats people differently. Congress passes a law that treats people differently. What power, what amendment? If Congress or the federal government passed a law, the Fifth Amendment is what applies. State equals 14th, federal equals 5th. So, I'll give you the weird hypo. If Congress passes a law that treats people differently, you would be thinking it's equal protection. But when you look at the answers, equal protection is not there. And they're just going to have one answer that says the Fifth Amendment of the Due Process Clause. You're thinking due process. I thought this was equal protection. But he told me that if Congress is passing a law that looks like it's either equal protection or due process, I have to pick the answer that says Fifth Amendment. So if you see Congress is passing a law, and even though it looked like equal protection, the only answer is due process, shut up and pick the only answer talking about fifth. Will they ever give me equal protection and due process, both? And no. My point is, if Congress is passing the law, just pick the only answer that will say fifth, and almost always there will only be one answer saying Fifth Amendment. When the state is acting and it's either an equal protection or due process violation, it will always be the 14th Amendment. Keep them separate and everything is okay. Good? Good. Let's keep going. Here we go. Let us go to a couple of little rules now also before we get to some more big stuff. Privileges and immunities. Privileges and immunities. I know many of you learn there's two of them, and, or, blah, blah. I get confused with that myself. This is what you need to know for the MBE, and this is how you get this MBE question correct, okay? Privileges and immunities. If a state passes a law which discriminates against you because you are not a, what's the buzzword? Resident. The state is passing a law that treats non-residents differently. They're discriminating against people because of their residency status. You are being treated differently. You are being discriminated against because you are not a resident of this state. If you're just being treated differently by a state, it looks like equal protection. That's why most of us get confused between equal protection and privileges and immunities. What's the one time in exam? It will be privileges and immunities when a state passes a law that treats non-residents differently because they are not residents. The whole crux of this question is about your status as a resident or not. You're literally looking for the R word. If you are being treated differently because you're not a resident, you can't get something in this state because you're not a resident. In order to get something, you must be a resident versus a non-resident. You are being treated differently or discriminated based on your status as a resident. You shut up and pick privileges and immunities and get the heck out of the question. Good? That's the word you are looking for. 13th Amendment. 13th Amendment versus the 15th Amendment. The 13th Amendment. Normally, as we'll talk about later, normally, in order for these issues to apply, equal protection, due process, etc., and others, there needs to be what? State action. There needs to be a government actor actually doing this. 13th Amendment says the following. 13th Amendment is actually ban slavery. 13th Amendment bans slavery. So the key now for MBE is if you see that there's racial discrimination, if someone's being discriminated based on race, while normally there needs to be state action to bring a claim, the 13th Amendment allows private individuals to be prosecuted for racial discrimination. 13th Amendment equals racial discrimination by a private individual, non-state actor, and that is you are allowed to go after the private individual. Normally, for one of these violations, you need state action, but not if it's based on racial discrimination. 13th Amendment, one-line rule like privileges and immunities. 13th Amendment equals racial discrimination, private actor, you can go after the private actor. 15th Amendment. 15th Amendment is about voting and race. If you are discriminating based on race and voting, we're talking 15th Amendment. You're trying to stop or make it difficult for people to vote based on their race. If you're looking at voting, racial discrimination, the amendment you are looking to shut up and pick is the 15th Amendment. 13th Amendment relating to race eliminates the state actor element. So if you're doing a 13th Amendment question, it's because they're trying to get you to know that a state action is not necessary and that a private individual you can go after them. If you're doing a 15th Amendment, it's also about race, but it's about discriminating in their ability to vote. So I give you a couple of these little one-liners. Privileges and immunities is affecting residents versus non-residents. 13th Amendment non-state actor, racial discrimination. 15th Amendment, race and voting. Just keep those separate. It'll be very fact specific. So when you get those answers, privileges and immunities, or 13th or 15th, you'll already know what you're looking for. Good? Good. Let's keep going. Here we go. Taking, the takings clause. The takings clause. The government shall not take private property for public use. They can, as long as they pay what? Just compensation. The government cannot take private property for public use unless they pay just compensation. Just compensation. This is the taking, the so-called actual destruction of your property. The government comes along and wants to build a highway, a stadium, a museum, a public park, and they need to blow up your house to take away your house for the land. Can the government take the private property for their public use as long as they pay you just compensation? Just compensation meaning the fair market value. The answer is yes. How are they going to test this? Number one, the big thing that's changed over the years is what's considered a public use, the public purpose. Why are they taking your land? It used to be that the public use must be literally for the greater good, something that the property or the project was owned by the government, the public land, the public park, a public museum, an open parking lot, something like that, the exit ramp, the highway. Now that public use, public purpose definition has been expanded, that even if a private individual or company owns that project or land, as long as it affects the public overall, the big picture, it helps jobs, the economy, tax rolls, etc. It has an overall greater good than it will be for the public use, even if a private individual or company will be benefiting or owns it. So, if the government wants to bulldoze John's house for a new highway to come through, can they do that? Yeah, because that's clearly a public use, as long as they pay me just compensation. What if they want to blow down my house to build, condos and shops and restaurants? Well, but the private individual, a private guy is going to own that. That's not for the public use. He's going to make all the money. But if the government makes the argument that the city, the town, etc., is dying and the economy we're all going to go bankrupt, and we need that project for the greater good, the public overall good, public use, to help the economy, jobs, etc., then is the power now very broad to be able to come and take your property if the government can show a public use? The answer is yes, it is. So be looking for the government taking private property for public use. For public use, that definition has been expanded, and as long as it has any overall public benefit, they can do that as long as they pay you just compensation. There's also something called inverse condemnation. Inverse condemnation, meaning your property is in effect condemned. Inverse condemnation. They're not coming along and bulldozing your house. You don't have to leave. They're not going to blow it up. They're just doing something that that denies you the economic benefit of your land. The fair market value of your land goes down to next to nothing, and you're going to say, no one would ever buy my house or my land. You've, in effect, taken my house from me. You've taken my property. So the taking is the physical knocking it down. The inverse condemnation is what you're doing, your activity, is now going to destroy the economic benefit of my land, so my property is worth almost nothing, which equals a taking, because in effect you've taken it because it's worthless now. So if you put the nuclear power plant across the street from my house, if you put the manure factory across the street from my house, can I still live there? Yeah. Do you have to bulldoze my house? Are you physically taking my land? No. But who the heck would want to live across the street from a nuclear power plant or a manure factory? If you put an exit ramp of a main highway right across the street from my house, I could live there technically, but I'm going to argue that you're basically condemned. You've basically taken my home, because if you destroyed the economic value, my house is worth nothing. Question. Just because the fair market value of your property may go down a little bit, that's not a taking. It has to reduce the fair market value so much that it's basically worthless, i.e. no one will pay. they always say that some fluctuations in price are, quote unquote foreseeable, so that's not going to be a taking. Be careful on that reading com question. Make sure that whatever the government is doing so reduces the fair market value of your property that it's basically worth nothing. That's what you're looking for, okay? So two types of those taking questions. Be careful. Even if the private company or private individual will own the actual project, it could still be considered a taking as long as it affects the public at large. Good? One or two questions maybe, reading comprehension. Now religion. We talked about equal protection, due process, religion, and speech. These are the four big ticket items. There's two issues, two concepts relating to religion now that we'll go over. There's the free exercise clause and there's the establishment clause. We'll do the establishment clause first. The government cannot pass any law which seems to establish a religion. Can't do something which seems to establish a particular religion. Okay? There can't be any preference for one religion over another. For the establishment clause by itself, there's a three-part test that we need to know some elements. It's called the Lemon test, just the name of a case. The Lemon test, to determine whether what the government does violates the establishment clause. Number one, part of the Lemon test. The law has to have a secular purpose. The law must be for a secular purpose. Secular meaning non-religious. Law must be for a secular purpose. Two, it may not advance or inhibit religion. The law can't advance or promote religion, but it also can't inhibit religion. And three, there shall be no excessive entanglement with religion. A buzzword, no excessive entanglement with religion. What is entanglement? It's usually money. No excessive entanglement with religion is usually the payment of money. Think scholarships, tax breaks, subsidies, like the government paying money to schools for programs. They're under the Establishment Clause. The government can't be seen to be subsidizing, sponsoring religion in schools. No excessive entanglement is usually the payment of money by the government to entities like schools to subsidize or to sponsor religion. So Establishment Clause, the government cannot make any law which seems to establish a religion, preference of one versus the other. Whatever they're doing has to have a secular purpose. I always say in all these common law chapters, always ask yourself, why is the government doing what they're doing? The statute. So if the government is doing something for a secular reason, it's not going to affect religion. The government can't promote or advance a religion. It also can't inhibit a religion. And the entanglement. A couple of classic examples. During the holiday season, every year during the holiday season, during Christmas, New Year's, you go to a government building, courthouse, governmental building, you always see a Christmas tree. You see a nativity scene. Isn't that promoting the Christmas holiday? Yes. Why is it allowed though? Because what you will generally also see, if it was requested to be displayed, is a menorah. And now, if the menorah wants to be, if the request is made to display the menorah, now must they do that? Yes. If they want some display to represent Kwanzaa, must that be represented also? Yes. Because if there was only a nativity scene or a Christmas tree, and there was a request for other religious displays to be out there, and it was refused or denied, now would they be promoting one religion and inhibiting other religions? Yes. That's why generally when you see these displays, everything is displayed equally, because now they can never be accused of advancing a religion while inhibiting another religion. If a government said, you know what, computer literacy is a really important thing. So the government wants to spend $100 million buying Dell laptop computers for all elementary school kids. Okay? Computer literacy, the government's going to spend $100 million buying laptop computers for every elementary school kid in the country. Now, some elementary school kids go to parochial schools, to religious schools. And some of those kids may upload contents of the Old Testament, the New Testament, the Quran, while they're using the government-bought laptop. Is that going to violate the Establishment Clause? No. Because why is the government doing it? For computer literacy. That's a secular purpose. Are they advancing or inhibiting any religion? No. They're technically subsidizing something, but is that subsidizing religious instruction? Are they buying laptops for kids for religious schools to study those religious works? No. For computer literacy, so that every kid could learn math, reading, science, internet, blah, blah, you get my point. That's for a secular purpose, and even though some kids may happen to use the laptop on their own in their schools for the religious purpose, that will not be a violation of the Establishment Clause. How will you know it for a secular purpose? They will tell you reading comprehension. Next is the Free Exercise Clause. Free Exercise Clause. Free Exercise Clause. Keep this separate from the Establishment Clause. Under the Free Exercise Clause, every citizen has the right to practice his or her religion any way they choose. Free exercise. We can practice our religion any way we choose. The government must remain neutral as to how we practice our religion. The government cannot comment on how we practice our religion. So there's the basic example of this question. The government is going to do something, some regulation, something. And one of two things is going to happen. Either the reason why the government is doing it is to stop you from practicing your religion. They can't do that because now they would be taking a position and they would be trying to stop you from exercising your religion any way you want. More often, the government's going to do some sort of regulation or law, and that's neutral as to religion, but the effect of that regulation or rule will stop me from practicing my religion the way that I want. If the rule on its face is neutral as to religion, has nothing to do with religion, but the effect of it will prevent me from practicing my religion, then it is not a violation of the Free Exercise Clause because the government wasn't trying to stop me. This is again one of those cases where a lot of you will get into your own head and apply your own public policy, Ralph Nader, Bill Maher theory of the world, leave all of that stuff out there for practicing law. On MBE, you must be religiously, no pun intended, haha, get it, religiously obedient to what the facts say. So if that fact pattern says the government regulation or law, whatever they're doing, was for another reason, then it has nothing to do with religion. You must believe that and take that at face value. I give this example to you. Yes, it's stupid and wacky, but it's real. It happened. And I think it gives you a good indication of what we're talking about. Okay, so put your pencil down. I know this is a long chapter. You need a quick break, but this is educational like always. In a former life, one of my former lives, John, I used to be a high school basketball coach. And I used to be a high school basketball coach at the private Hebrew day school that I attended here in South Florida. And I'm proud to say that the school, they had never participated in athletics. And we were the first private day school in the state of Florida to participate in high school athletics. And so we were always playing against all these schools, of course, these other Catholic schools, private parochial schools. So of course, we were terrible for the first several years. And we would play these games and we'd be losing by 30, 40, 50 points. So we played this game one time and we were getting killed as usual. And then all of a sudden, the ref stopped the game. And he stopped the game because the kids, the players for my team, as attending a religious school, were wearing the yarmulke, wearing the head covering. And the ref stopped the game because there's a Florida State High School Athletic Association rule that student athletes are not allowed to wear jewelry or any headgear for school safety. Okay? They can't be wearing the chains, rings, necklaces, or any headgear because that would be a problem for the safety of the other children. So the kids, while wearing the yarmulke, had the metal bobby pin to keep the yarmulke in there while they were running around. So the ref stopped the game because the metal bobby pin was technically headgear and thought that it could hurt some of the other children. I, of course, even though this was before I went to law school, came up with an ingenious argument. I said, ref, I know where you're going, but our kids, we can't jump more than 2 inches off the ground. This is not going to affect school safety. Our kids can barely get off the ground and we're 6 inches shorter than everybody else. That's why we're losing by 50 points. I thought it was an ingenious argument. He didn't go for it. And the rabbis were not going to let the kids run around without wearing the yarmulke. So the Florida State High School Athletic Association rule, which prevented any headgear, if the referee took off the yarmulke, what was that going to do? In effect, it was stopping the kids from practicing their religion the way that they wanted to, and we couldn't continue the game. So what ended up happening? All the mothers were yelling at me. You see, I told you all these people are anti-Semitic, and I would have to yell at all the Mrs. Schwartzes and Goldbergs, shut up, because, you know, the mothers were crazier than the little kids, so I'd have to keep them quiet. And now I'm thinking to myself, oh my God, what are we going to do? What's the point? Was the Florida State High School Athletic Association rule unconstitutional? Did that stop us from practicing our religion? It stopped the kids from practicing their religion, but was it unconstitutional? No, because what was the regulation for? School safety. The headgear was for school safety. That was neutral as to religion. The effect of that rule stopped the kids from practicing, but it was not unconstitutional. If there was some sort of rule that they didn't want Jewish children playing basketball, would that obviously be a different story? Yes. So what are you looking for on an MBE question? That the law, the regulation the government is doing is neutral as to religion. The effect is a different story, okay? There's a famous Supreme Court case, not to just talk about, one thing, but there's a famous Supreme Court case about I believe it was a Navy or an Air Force pilot in the armed services who was Jewish. And he wanted to wear his yarmulke in the cockpit while he was flying. But there are dress code, all kind of dress code rules in the armed forces. And again, everyone has to be uniform, the dress code. And again, no jewelry, no headgear, nothing different. And so there was an issue of the yarmulke wasn't being, the restriction against wearing the yarmulke wasn't to discriminate against the free exercise of religion. It was to promote the uniformity of the dress code. Always be looking at what was the regulation about. And as long as it was neutral as to religion, then it will be constitutional, even if the effect seems to stop someone from practicing their religion. Good? Good. All reading comprehension. Now let's get to speech. We have equal protection, due process, religion, two types of religion, free exercise clause versus the establishment clause. Now we'll come to speech. Now I know you're groaning because speech can get very, very detailed. There's a lot of minutia in this. Keep it simple and separate. We'll do that. We'll give you some basic one-line rules and everything will be okay. Good? Good. The first thing you always want to do on a speech question, okay? First thing you want to do in terms of approach on speech. More often than not, they're testing you on the two ways that you can regulate speech. There's content-based versus content-neutral. Content-based versus content-neutral. Okay? You're doing a speech question. What is content-based about? Content-based regulation is when the government is trying to stop the message from getting out. They're literally just saying no. You want to march, you want to parade, you want to demonstrate, you want to take out an ad in the newspaper, put a billboard up, and you ask for the government for a permit. What does the government say? No. Content-based regulation means they're trying to shut the message down, shut you up. They're basing the regulation on the content, content-based. They're saying no. So if you want to go march, parade, demonstrate, and the government simply says no, aha, now I know I'm doing content-based regulation. And what's the point of content-based? It triggers strict scrutiny. It triggers strict scrutiny. Same test like we talked about before. So if you see a hypo where a group of people want to march, parade, meet, talk, get together, take out an ad, to do a TV, any kind of speech, expression, get together, and the government says, no, we refuse, period, that's content-based and will trigger strict scrutiny. What if the government doesn't say no? The government says, well, not the way you want, but we're going to tell you where, when, and how to march, demonstrate, or speak or get together. That is called content neutral. What the government is doing is neutral as to the content. We're not trying to stop you from get the message out. You can say and do whatever you want. We're just regulating where, when, and how you say it. That's called time, place, and manner regulation. Time, place, and manner regulation. Will that generally be constitutional? Yes, generally it will be constitutional if it furthers a significant governmental interest, and leaves open alternative means of communication. It looks like a form of mid-level intermediate scrutiny. My point is, when you're doing content neutral, never pick anything that looks like strict and never pick anything that looks like rational. You're looking for something that talks about intermediate because it furthers a significant governmental interest. Sometimes you may even see something where it says important, but most of the time it'll say significant governmental interest and leaves open alternative means of communication, which means what? We're leaving open another way, another time, another place. Content neutral. You can get the message out, but it's time, place, and manner. So, again, not talking politics, I'm just talking constitutional. Demonstrations in front of the White House, demonstrations on the front of the fence of the White House on Pennsylvania Avenue. Okay? There was a famous demonstration some years ago, Occupy Wall Street. People were upset about Wall Street and capitalism. They went and they sat there on Wall Street. They demonstrated on Wall Street for days and weeks. Every time there's a demonstration in front of the White House for whatever reason. If the group of people who wants to march or demonstrate requests and wants to get the permit, wants to get out there and demonstrate, if the government said, no, get the heck out of here, you can't come here, they know they generally can't do that because that would look like content-based, meaning it would trigger strict scrutiny. It triggers strict scrutiny because if you're stopping the whole message from coming out, what are you really doing? It looks like you're banning speech. It looks like you're just shutting the whole thing down, which is pretty much what you are. And what is speech? A fundamental right, and fundamental rights trigger strict scrutiny. So when the group says we want to go get a permit to march on Saturday in front of the White House, if the DC police said no, not at all, then that would trigger strict scrutiny. So what do they usually do? They usually say, okay, you can go here from 8 a.m. to 4 p.m. You've got to be 20 feet away from the fence of the White House, and you can't go on the roof of the buildings. The group, the people are always like, no, First Amendment, I can do whatever I want. We want to go anytime. We want to be here for weeks. We want to go on top of the fence. No. Can the government regulate the time and the place and the manner of the speech? Yes, as long as it's reasonable. As long as it's reasonable. As long as they can still get their message out, which they almost always can, they can still regulate the how and the where and the when. So, if you're just looking at a hypo and a group wants to protest and the government entity says no, you're looking for content-based, strict scrutiny. If they say no, but you've done too many questions that day, and you see the word no or we're not going to allow it like that, and you skip and go down to the answer and you realize I got the question wrong. Why? Because you didn't slow down and say, well, it said not like that, comma, but we'll let you do it from 12 to 3 p.m. You can't do it here, but you can do it over there. Time, place, and manner. If everything is fact-based, the questions will look the same. You have to make sure you're noticing whether they change the way the facts are written. Content neutral equals a form of intermediate scrutiny and generally is constitutional. Content-based triggers strict scrutiny, and you're looking for the strict scrutiny test. There are a couple of specific versions of content neutral, couple of specific versions. Sometimes, and most of the time I should say in content neutral, it affects what's called a public forum. Public forum. Public forum means that the conduct is occurring on streets and parks. Usually that's where you're going to find these protest demonstrations, and you apply the test that I just mentioned. Significant governmental interest leaves open alternative means of communication. Public forum, streets and parks, public obviously, streets and parks, you apply that test. Once in a while you'll get the so-called non-public forum. Non-public forum. What is that? Those are on billboards and buses, something like that. A billboard, a sign, something like that, a placard that's on a bus called a non-public forum. You're looking for some sort of a sign like that. Then you're looking for where the regulation has to be reasonably related to a legitimate interest. If you see a very narrow scope where your expression is on some sort of a sign like a billboard or on the side of a bus. You're talking non-public forum and you're looking for the buzzword reasonably related. As long as the regulation is reasonably related to a legitimate interest, then that's the buzzwordy definition you are looking for. Big picture, keep the content-based separate from content-neutral, and you're okay. There are now some specific kinds of questions where you have to know what the facts look like. The next group of hypos and questions we'll do are relating to things called unprotected speech. Unprotected speech. Some people think it's under First Amendment, I could say whatever I want, whenever I want. It's not true. Can the government regulate speech? Yes. But are some forms of speech unprotected? Are some forms of speech such that, for whatever reason, the government does not give you the First Amendment right to say it, and therefore you can't? The answer is yes, and the government can step in and shut it down. These are unprotected forms of speech. Number one, obscenity. If something is obscene, then the government can go in and shut it down. There's no First Amendment protection. As we probably know, obscenity has a long definition. I'll give you the elements now, and then I'll tell you pretty much how it's tested. So get ready with your pen or pencil or your fingers, get the law down, and then we'll talk about it. Something is obscene, definition. Something is obscene if, number one, element one, an objective person, a reasonable person, applying local community standards, finds that the work appeals to the prurient interest in sex. By an objective standard, applying to the local community standard, the work, the picture, the sculpture, the picture, the magazine, the book, whatever it is, appeals to the prurient interest in sex. What's the key element there? That it's an objective standard to the local community standards. Local community standards. We'll talk more about that in a minute. The second element of something being obscene is that the work depicts sex in a patently offensive manner. Patently offensive manner. 3, buzzwordy definition, 3, the work lacks any serious literary, artistic, political, or scientific value. The work in question lacks any serious literary, artistic, political, or scientific value. Those 3 prongs, those 3 elements of the test would make something obscene. In 1.8 minutes on an MBE question, can you apply all that law? No. That's why most of the time something is obscene for MBE purposes. They're generally going to test you on the local community standard. Is something obscene based on that particular local community standard? The example generally will be if you have a movie, a picture, an art display, whatever it is, and it's in places like San Francisco, Greenwich Village in New York, South Beach in Miami Beach, places that are more liberal. Something could be very popular, which would be a little risque. But then you have conservative cities and states where if you put the same piece of art or picture or book or magazine or movie, people would be very offended because to them that would be applying to the prurient interest in sex. That's too obscene for us. Why is it okay in one neighborhood and in one community and it's not okay in another? Because we apply what's obscene based on local community standard. Once again, this is reading comprehension. So can something be okay in one community, meaning not obscene, because we're all okay with it, versus obscene in another? Yes, because there, based on a reasonable standard, it would apply to local community standards. It applies to the prurient interest in sex. So when you're doing an obscenity question, more often than not, they're distinguishing it based on the local community standard. That's what generally you're looking for. And if so, it's obscene and not protected by the First Amendment. 2, speech which affects a clear and present danger. Clear and present danger. Speech that incites imminent violent action. Speech that incites imminent violent action and likely to produce such action. So clear and present danger, there is some speech that can incite violence, imminent violence. We've seen those kinds of examples in the news. and it would likely produce such action. So if they're afraid, man, this person or this group is really inciting violence and it could happen right now, that would be considered a clear and present danger. It is not protected and the government can shut it down. Similarly, fighting words. Harsh language likely to incite an average person to commit violence. You see, that sounds very much the same. Usually the fighting words is more based on an individual. Clear and present danger is usually more as a group or a large band of people could be committing violence. Either way. If we're talking either one of those where someone is saying something, someone's doing something in their speech, which is going to rile people up for violence, to create violence, incite violence, either one of those, clear and present danger or fighting words, there is no protection and you could shut it down. Commercial speech. You can regulate commercial speech, business. You can regulate commercial speech if there's a, quote, give you the definition, if there's a reasonable fit to a substantial governmental interest. When can the government step in and regulate commercial speech, business-related speech, anything out there commercial? If there's a reasonable fit to a substantial governmental interest and it's narrowly tailored. Reasonable fit, substantial government interest, narrowly tailored. So if I see a question that looks like it's talking about commercial speech, something about business, the government may regulate it, and the buzzwordy definition that I'm looking for will include some or all parts of the phrase reasonable fit, reasonable interest, reasonable fit, to substantial government interest. Once again, never pick compelling, never pick rational. You're looking for reasonable and substantial if we're talking commercial speech. False advertising or misleading advertisement is not protected. False advertising or misleading information is not protected. You have sometimes, you've seen a commercial, a product, promising it's going to do miracles. These infomercials sometimes. God forbid, somebody's bald. Oh, you take these vitamins, you're going to grow hair. You're going to grow 6 feet tall. All these crazy commercials you see sometimes. If it turns out that that's false or misleading information, can the government step in and shut that down? Yeah. The people who are doing the commercial can say, this is First Amendment. I can do whatever I want. No, you can't. If you're giving out false or misleading information, then the government can shut you down because it's not protected. Good? Good. Few more. Let's move along. Suck it up. Here we go. Prior restraint. Weird hypo, does not come up much, but again, one time you could check it. You can catch it if it's in the facts. Prior restraint. The government cannot stop speech before it's ever published. You're basically looking for things like injunctions or gag orders. You're shutting the speech down before it ever had a chance to get out. Prior restraint. You're restraining the speech prior to before it can get out there. Rare that it'll be tested, but once in a while you can get it. Prior restraint, you're looking, as I said, for some sort of injunction or gag order where you're basically shutting it all down in anticipation of the speech. Unfettered discretion. A government official cannot choose one form of speech or another, or allow one form of speech or another. If the government official, mayor, etc., is going to allow one form of speech, they must allow all forms of speech. If you cannot choose one versus the other. This is a weird hypo when and if it is tested, but it should generally look pretty obvious that the government official is basically saying, well, you can say this, but you can't say that. And as soon as you see some sort of a preference for one versus the other, then you know that's unconstitutional because that's unfettered discretion. Next, the next two also look the same, just be careful. Speech that is overbroad. You probably learned in law school, you can always argue vague and overbroad. Good. So speech that is overbroad is not allowed. A statute cannot be too broad. You're just listing so many different forms of speech. It's too broad, overbroad. That is unconstitutional and can shut it down. Similarly, the law or the government activity, the speech cannot be vague. It cannot be vague. What's the buzzword you usually see in a statute or a law which it's too vague? Any. The government's trying to prevent any this, any that, all of that. Words like any or all, you should be thinking that's overbroad or too vague, and it's unconstitutional. So anytime you see those broad, any, all kind of statutes, you're thinking, ooh, I think they can shut this down because they're talking about something that's overbroad or vague. The government can shut it down. Again, a couple more now. One-liners, you may, and I emphasize the word may, get one question on a couple of these. They each have their own little thing. Keep them separate. One-line rules, and we're okay. Bill of attainder. Bill of attainder. These are, again, some of these things where you'll see them, and they'll generally tell you, oh, these are usually the wrong answer. Yep, they're usually the wrong answer because they don't apply. What's the one time when it does apply? I'm greedy. I want you to get these questions when and if you see that the facts are giving you the evidence. What is a bill of attainder? A bill of attainder is a law that punishes an individual or a group of people. You're literally looking for a name of the person or the group. They're expressly, on its face, punishing either civilly or criminally an individual or a named group of people. Federal or the state government cannot do this. There can be no bill of attainder by either the federal or state government. If Congress or the state of Florida passes a law saying we're going to fine John Grossman $50,000, we're going to fine jet fans $25,000 apiece because they're too obnoxious. You're now punishing civilly or criminally an individual or a group. Now, some of you may be thinking, this is going to be tough to distinguish between equal protection. Hear me out. Don't write this down. Bill of attainder is imposing penalties, civilly, i.e. fines, or criminally, putting me in jail. That's what makes it a bill of attainder. And that's why generally it's not the right answer, because generally it's not doing that. When is it the bill of attainder question, John? And I should shut up and pick bill of attainder. When I see the named person, individual, or group of people is being punished, either civilly or criminally by the federal or state government. That's the bill of attainder. Shut up and pick it. Ex post facto. Ex post facto. That is where a law makes something criminal that previously wasn't a crime. When I committed it, when I did it, it was constitutional, it was okay. Now you're passing a law that retroactively makes it illegal. That is unconstitutional, and you cannot do that. The state or federal government cannot do that. So on January 3rd, I'm driving 60 miles an hour, and 60 is okay. The speed limit was 65. Now on April, May, June, or July, you're telling me that as of January, the speed limit is 55 and you're trying to give me a ticket. If you're going back in time, that is not allowed. Back in time is not allowed. And therefore, that is also called unconstitutional. Yeah, so ex post facto, retroactive, you're going back in time to make something what was legal now illegal. You cannot do that. State or federal government. Contracts clause. Contracts clause. The state, this is affecting only the state. A state cannot pass a law which would impair your ability to enter into a contract. And again, this has to be very express. Don't infer this. The law has to expressly limit your ability to enter a particular contract. Once again, that's why usually this is the wrong answer, because usually it's not expressly doing it, but you can argue maybe that eventually would. No, that's why it's rarely correct. When is it the contracts clause question? When in the government statute, in the law, government is expressly stopping John from entering into a form of contract, a certain kind of contract. It's unconstitutional under the contracts clause. Lastly, we referenced this before, state action. State action. If John, private guy John, if I had a sports bar, I had a sports restaurant, and I wallpapered it with all my Jet pictures, uniforms, Broadway Joe Namath was all over the place. Everyone has to wear a green jersey, ha ha ha. And I own my own sports bar. Now, most real sports bars have the TVs and they have all the NFL games on Sundays. My sports bar will, of course, only have the Jet game on TV. And when the Jet game isn't on TV, we'll have classic Jet games. Not that there's many of those anyway, but we'll have them on TV. What's the point? A woman comes into my sports bar. She's a Jet fan. But I say, I'm sorry, you're not allowed. This is a men's only restaurant. Why? Because when John was a kid, I was a big fan of the Little Rascals, back when they were popular. John was a huge fan of the Little Rascals, and every Little Rascal fan knows that the Little Rascals were members of the He-Man Woman Haters Club. And Darla was not allowed, the one girl in the Little Rascals, was not allowed in the club because it was the He-Man Woman Haters Club. So since John takes the Jets very seriously, as you've kind of referenced and seen over the last several videos, I don't want any distractions on Sunday. And in honor of the Little Rascals, my sports bar is men's only. Unbeknownst to John, the woman is a lawyer. And she says, I'm going to sue John based on equal protection because I'm treating her differently because of her gender. It's not, no women are allowed. Under the federal Constitution, what we've been talking about, federal con law, can John keep her out? Is that constitutional under the federal Constitution? Yes. Why? Because there's no, state action. In order for there to be a violation of the Constitution, there must be state action. Whoever is doing the activity must be a state actor, must be government action. And if John's a private individual, I can do whatever I want. Yes, take it easy, don't email me. State laws, state civil rights laws, I'd be out of business in 38 seconds if I tried to do that. But my point is, under the federal Constitution, MBE, can I do that? Yes, because there's no state action. A couple of other real examples. Just again, because we're ending, you're tired, put the pencil down, just listen. For years, there was a famous thing for years where you had the Boy Scouts and the Girl Scouts. And for years, it was the boys and the girls, and that's it. Some years ago, and I honestly don't remember which one, a boy wanted to be in the Girl Scouts or a girl wanted to be in the Boy Scouts. I don't remember which one. And the issue was, can the organization prohibit that on their own? And the issue was here that those organizations, the Boy Scouts and the Girl Scouts, get federal money. So some of you are already thinking about, John, you could be a private actor, but aren't you sometimes acting like an arm of the state? If you get so much governmental support, can't you become like, if you get money, then you're like it? Don't do that. I'm screaming, don't do that. If they tell you in the fact pattern that you're a private actor, you're private. Could you become a state actor? Yes, but you have to get so much money, so much support, so much that you're basically working for the state. You're not your own person, which is generally not going to happen. Could it? Yeah. My point is, they say John owns a restaurant, ABC Inc., private organization, you're private. That's where you want to go. And just because I may get a tax break, a scholarship, a subsidy from the government, that's not going to be enough to make me a state actor. You with me? So, could the Boy Scouts have kept out the girl or vice versa? Yeah, but the issue is if they're getting so much of their money from the government that they're basically a government institution, then state action will apply, and we can't do this. So if you see private organization, private John, seems to be discriminating, can I do that? The answer is yes, because I'm a private actor and not a state actor. Good? Good. Take the pencil. Whew, big deep breath. That's a lot of law, John. Yeah, it's a lot of law because it's worth half of all the freaking con law questions. So that's why it's big. Now let's go back. Just stare at me, 30, 40 seconds and we're done. Equal protection. You don't even have to look at your notes. Equal protection, the government's treating a group of people. How many levels of scrutiny? 3. 2 types of equal protection questions. They're either making me know what equal protection looks like. It's about when people are being treated differently. Or it's going to say John sues a violation of the Equal Protection Clause, or what's the burden of persuasion. And I know to match the burden with the buzzword, 3 levels of scrutiny, and everything is okay. Substantive due process. All people can't do something. All people must do something a certain way. We're talking about our rights. Some rights are fundamental. That triggers strict scrutiny. Most rights are not fundamental. Rational basis. Done. Procedural due process. Notice and a hearing. But notice and a hearing only apply if I have a property right, property interest. Then I get notice and a hearing. Religion, Establishment Clause, Free Exercise Clause. Keep them separate. Speech, content-based, content-neutral. I know a couple other unprotected forms of speech. I'm okay. And we have our little one-liners, as I like to call them. 13th Amendment, 15th Amendment, state action, ex post facto, privileges and immunities, make separate cards, make separate lists. And when you get down the buzzwords, what should you do? Don't put the outline down and then just come back and read it, because what do you do when you're doing this? Okay, when you're tired and pissed off and cold like you are right now and you want to go enjoy yourself a little bit, what do most people do during their studies? They sit on their couch and they go, you see, yeah, I know this, I know this, I know this, and you skim the words, but you're not memorizing, which means you can't spit it out. Always be memorizing. Leave the gun, take the cannoli. That's exactly right. You didn't have to make a flashcard. What does the beautiful Scully say from the X-Files? All things being equal, the simplest answer is always the correct one. And how do I know what that simplest answer is? What was in the fact pattern? Connect the dots. And once I know what that issue is up there, I shut up and pick it down there. Go get them. You can do this. I have confidence in you. Good luck.